This video is brought to you by Brilliant. The State of Israel is at the International Court of Justice facing accusations of genocide against Palestinians in Gaza, having been taken to the World Court by South Africa. This raises a lot of questions. What exactly is Israel being accused of? Why has South Africa initiated proceedings? What can the court actually do? And what happens next? In this video, we'll answer these questions and explain the landmark legal battle. Before we start, if you haven't already, please consider subscribing and ringing the bell to stay in the loop and be notified when we release new videos. Firstly, let's get some important things out of the way. Like, what is the International Court of Justice, or ICJ? The ICJ is the principal judicial organ of the United Nations. It settles disputes between states and gives opinions on issues of international law. It is not the same as the ICC, or International Criminal Court, which confusingly is also based at The Hague, but instead investigates and prosecutes individuals for grave crimes like crimes against humanity. So forget about the ICC, we're talking about the ICJ. In South Africa's application to the ICJ, it accuses Israel of acts and omissions that are genocidal in character, as they are committed with the requisite specific intent to destroy Palestinians in Gaza as a part of the broader Palestinian national, racial and ethnic group. Countries that are party to the 1948 Genocide Convention, including Israel and South Africa, are obliged not to commit and to prevent and punish the crime of genocide, which is defined in the Convention as acts committed with intent to destroy in whole or in part a national, ethnical, racial or religious group. In a moment, we'll look at the case put forward by South Africa, but first we should explain a little more about the context and procedure. Cases brought to the ICJ alleging a violation of the Genocide Convention are relatively rare. Bosnia brought a case against Yugoslavia in 1993, and Ukraine did so against Russia in 2022. Notably, in 2019, the Gambia brought a case against Myanmar, accusing it of genocide against the Rohingya people. That was the first time such a case had been brought by a country not directly affected by the action of another. South Africa's case is in the same vein. While obviously not directly involved in the situation in Gaza, South Africa is asserting its right and obligations as a party to the Genocide Convention to prevent genocide. But why South Africa exactly? Well, South Africa has been a vocal critic of Israel's actions in Gaza, and the ruling African National Congress and former anti-apartheid leaders have had long-standing ties to the Palestinian cause, often drawing parallels, denied by Israel, between modern-day Israel and apartheid-era South Africa. Oral hearings began on Thursday, January the 11th, but a definitive ruling by the ICJ on whether Israeli actions amount to genocide will take years. In the meantime, the case is at the provisional measures stage, which means the ICJ's 15 judges, plus one each from South Africa and Israel, will, in the near future, possibly this month, decide on whether to issue legally binding provisional measures requested by South Africa to prevent further harm in Gaza while the case continues. Among the requested measures, South Africa is calling for Israel to immediately suspend its military operations in and against Gaza, prevent the destruction of evidence, as well as to facilitate access to sufficient humanitarian assistance. If some or all of these provisional measures, or indeed different provisional measures, are issued by the ICJ, they will be legally binding. However, the court basically does not have the power to enforce them, raising the possibility that Israel will simply defy the court. This is what happened when the ICJ issued provisional measures ordering Russia to halt its invasion of Ukraine in 2022. Russia said no and continued. But that doesn't mean that South Africa's case is futile. Any provisional measures issued by the ICJ will add to the international pressure on Israel to stop or scale back its offensive in Gaza, and defiance of this could cause further reputational damage to Israel and put its allies in an awkward position. If the case was actually pointless, Israel might not be taking it so seriously. An Israeli diplomatic cable seen by Axios states that a ruling by the court could have significant potential implications that are not only in the legal world, but have practical bilateral, multilateral, economic and security ramifications. So what exactly has South Africa put forward in its case? In the 84-page-long application to the ICJ, South Africa points to the killing of Palestinians in Gaza in large number, now more than 23,000, the causing of serious bodily and mental harm, the inflicting of conditions of life intended to bring about their destruction, including expulsions and mass displacement, the large-scale destruction of homes, deprivation of access to adequate food, water, medical care, shelter, sanitation, and more. It also brings together assessments by UN bodies, officials, and experts who have raised concerns about Israel's conduct, and points to UN-published figures of 148 UN staff, at least 326 health workers, and 112 journalists being killed. Crucial to the case, though, is what South Africa says is evidence of Israel's genocidal intent. Pages 59 to 67 set out this apparent evidence, listing comments made by the Israeli Prime Minister, President, ministers, military officials, and more. For example, President Isaac Herzog saying it's an entire nation out there that is responsible. It's not true, this rhetoric about civilians not aware, not involved. Defense Minister Yoav Gallant announcing a complete siege on Gaza. No electricity, no food, no water, no fuel. Adding, we are fighting human animals. A deputy Knesset speaker saying, we all have one common goal, erasing the Gaza Strip from the face of the earth. And Israeli soldiers chanting, there are no uninvolved civilians. Here's an excerpt from the South African lawyer at the ICJ on Thursday.
Yet, the distinctive feature of this case has not been the silence as such, but the reiteration and repetition of genocidal speech throughout every sphere of state in Israel. We remind the court of the identity and authority of the genocidal inciters. The scale of destruction in Gaza, the mass targeting of family homes and civilians, the war being a war on children, all make clear that genocidal intent is both understood and is being put into practice. The articulated intent is the destruction of Palestinian life in all its manifestations.
So how has Israel responded? Israel has vehemently rejected the allegations as atrocious and preposterous, and has accused South Africa of playing advocate of the devil for Hamas, with Prime Minister Netanyahu saying, it is not we who have come to perpetrate genocide, it's Hamas. Netanyahu also put out a statement ahead of the court session stating,
Israel has no intention of permanently occupying Gaza or displacing its civilian population. Israel is fighting Hamas terrorists, not the Palestinian population. And we are doing so in full compliance with international law. The IDF is doing its utmost to minimize civilian casualties, while Hamas is doing its utmost to maximize them by using Palestinian civilians as human shields.
Ahead of Israel's oral arguments last Friday, its delegation was expected to assert its right to self-defense following the October the 7th Hamas attack. Highlight actions by the Israeli military to avoid civilian casualties like evacuation warning messages, its allowing in of some humanitarian aid, and statements by Israeli officials saying Israel is at war with Hamas, not the Palestinian people. While countries, including Turkey and Jordan, are backing the South African case, the United States, Israel's staunchest diplomatic ally, has described the case as meritless and counterproductive. Other Western countries have largely remained relatively silent or issued cautious statements in support of the ICJ as an institution, while not supporting South Africa's case. Regardless, we'll have to wait and see in the coming weeks if the ICJ judges do issue provisional measures, what those measures are, and how Israel and the rest of the world responds. Because once the ICJ makes a decision, even just on provisional measures, it will be a lot harder for countries to equivocate on the case. As we step into 2024, many of us are contemplating our New Year's resolutions, always looking to improve ourselves and learn more about the world around us. And while our content is always a good starting point, a lot of stuff we talk about can seem pretty complicated, especially when we dive into analytics and detailed data. But luckily there's a fun and easy way to learn more, which also doesn't cost thousands of dollars or take years and years of schooling. That's because Brilliant is the best way to learn maths, data science, and computer science interactively. And the good thing is, it doesn't take long to learn either. These complex topics are broken down into small but accessible chunks, designed around your busy schedule. Even just a few minutes a day can help you with accumulating new knowledge over time in a fun and engaging way. As time goes on, you'll also get used to that empowering feeling of learning too, because Brilliant isn't just about memorization and lectures. Brilliant teaches you by doing, using active learning techniques to teach you the principles behind otherwise quite complex subjects, and ensuring you actually understand what's going on. So whether you want to brush up on your basic maths skills, improve your employment prospects, or just have another New Year's resolution for 2024, you can check out everything Brilliant has to offer free for a full 30 days by going to brilliant.org/TLDR. Plus, the first 200 of you will get 20% off Brilliant's annual premium subscription. Thanks for your support.